This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why dealing with people who commit fraud gets no good deed going unpunished, and why Geico sued fraudulent health care providers under RICO, settled with the defendants, and then found they failed to pay the settlement amount. Default of a settlement agreement was therefore reduced to a judgment because the fraudsters felt that they could get away with it and didn't even respond. In Government Employees Insurance Company, or companies at all, known as Geico, versus Dominic Emeka Onyema, MD et al., the United States District Court for the Eastern District of New York on July 9, 2025, ruled against the settling fraudsters. Plaintiff Government Employees Insurance Company and other Geico companies sued Defendants Dominic Emeka Onyema, MD et al., alleging breach of a settlement agreement entered into by the parties to resolve a previous fraud-related lawsuit. Geico moved the court for default judgment against the defendants, and the June 19, 2025 report and recommendations of the Honorable Joseph A. Marutollo, the United States Magistrate Judge, which recommended that the court grant plaintiffs' motion for default judgment against the defendants and awarded plaintiffs a total of $456,665.65 plus pre- and post-judgment interest. The United States District Court adopted the recommendations of Judge Marutollo through his reported recommendations in full. The background of the case was that in October of 2021, plaintiffs Geico and defendants were involved in a lawsuit for an insurance fraud scheme in which the defendants used DEO defendant and Healthwise defendant to unlawfully bill plaintiffs and other New York automobile insurers seeking payment of no-fault benefits for medically unnecessary, illusory, or otherwise non-reimbursable health care services. Plaintiffs asserted claims against the defendants for violation of the Racketeer Influenced and Corrupt Organization Act, common law fraud, and unjust enrichment, and sought money damages against them in excess of $590,000. On April 27, 2023, the parties entered into the settlement agreement whereby the defendants agreed to jointly and severally pay plaintiffs the sum of $325,000 divided into a series of payments as detailed in the settlement agreement. The defendants made the initial payment followed by 2 installment payments as stipulated in the settlement agreement. However, the defendants failed to make any subsequent installment payments, allegedly in breach of the settlement agreement. Plaintiffs notified the defendants of their breach pursuant to the terms of the settlement agreement and demanded that the default be cured per the agreement. Defendants purportedly failed to cure the breach, and these liquidated damages entail $500,000, less any amounts paid through the date of the payment default. Later provisions in the settlement agreement make clear that the amounts paid that are to be submitted from the liquidated damages total are only the installment payments. Defendants failed to file any objections to the report and recommendation within the 14 days prescribed by statute. Therefore, the court ruled: 1. $456,666.65 in liquidated damages for which defendants are jointly and severally liable to Geico. 2. Prejudgment interest in the amount of $112.60 per day between March 7 of 2024 and the day judgment is entered. And 3. Post-judgment interest in an amount to be calculated by the clerk of the court pursuant to 28 United States Code Section 1961. The court adopted the reported recommendations in its entirety and granted plaintiffs' default judgment and found defendants jointly and severally liable in damages and pre- and post-judgment interest. In my opinion, people who commit fraud are not good and honorable people. Geico, with clear evidence of fraud, sued the healthcare provider defendants under the RICO law. Geico, acting honorably, entered into a settlement agreement with the fraudsters who made about 2 to 3 of the agreed payments, only to force Geico to effectively sue again to get a judgment to enforce the settlement agreement plus interest, which the defendants ignored, believing they could avoid collection, teaching Geico and all insurers to never enter a settlement agreement with fraudsters where they would pay a judgment or an agreement with timely installment. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and gain access to the more than 5,100 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. They're free. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.